We have a special guest with us, the 49th, going to be the 49th Chief Justice of India, Justice UU Lalit, who's been elevated to this post, probably the second person in the bar to have come up to the post of CJI. Many congratulations. So what will be your focus?
Thank you.
So Justice, what will be your focus I know you have a very short tenure, but what would be your focus in that short tenure that you are going to be the Chief Justice of India?
See, focus like any other Chief Justice would be to see that on the administrative side, whatever maximum output can be achieved through the limited resources, that is the achieving of that, to see that qualitatively the kind of matters which get listed should be such which are capable of disposing of many pending matters in the lower authorities. For instance, as I see it, if there is an issue on, say, income tax matters, on a particular provision which is pending consideration in Supreme Court, because the issues are capable of reoccurring every now and then, so therefore sooner you dispose of, the better, because the pending matters in high courts, tribunals will also get disposed of. That's one part. Second part is that the basic function of the court, Supreme Court, is to lay down law, to interpret constitution. So therefore, as and when such occasions come, the matters be listed as early as possible before the appropriate strength, to see that the output is maximized. That's essentially the function of the Chief Justice.
So you are going to try to club cases as far as possible to ensure that
not necessarily clubbing the cases, but to see that clubbing is one part of it, but that's not the whole answer. So say for instance, whenever clubbing will be easy and conducive to good disposal, we will certainly do that. But at times clubbing also sort of involves too many representations, too many lawyers, so therefore that elongates the process. So in such matters, take representatively just one or two matters, list them together, so therefore the law gets laid down, then you can follow that legal principle in the rest of the matters. So clubbing is only one idea, but the basic idea is to see that the disposal is qualitatively of such output which will essentially ease the pressure on the legal system.
And set a legal precedent.
Absolutely.
The other issue, sir, which has started an unnecessary debate about whether the Chief Justice of India can actually be the master of the roster. I mean, administratively you have been, and this has been decided by a constitution bench. How do you respond to that debate? Because many of your points that you're putting out, starts from this very issue.
See, master of the roster, the roster can certainly be fixed by the Chief Justice, saying that in this particular court, these kind of matters be listed. Of course, there are always 2-3 alternatives for every kind of matter, but then this is the broad outline of the roster which is fixed by the Chief Justice. Second part which the Chief Justice has in his jurisdiction of powers is to fix or have the composition of the bench, whether 2 judges or 3 judges or what kind of benches, whether in A should be sitting in the company of Z or not. So therefore that's kind of fixing or having a particular bench. These are matters which are certainly within the jurisdiction of the Chief Justice. The third matter could be that very well, in case you want certain constitution benches matters to be disposed of at an early date, then fix the bench, constitute a bench, and therefore list the matters before that bench. So these are matters which are certainly within the competence and within the jurisdiction of the Chief Justice. What happens in every individual case, whether that case be listed going by the roster, that is something which must normally be done purely on objective basis.
And that has come into a lot of questions in recent past. So how do you respond to that? In terms of...
I don't know whether for what reason it has actually been questioned in recent past, but this has always been going on. So therefore, say for instance, my court, my roster is fixed. Say maybe criminal matters, service matters, or National Commission consumer dispute matters, indirect tax matters, tax matters. So this roster is fixed. In that roster, certain matters, because there is a parallel roster which may be fixed for the 2-3 other courts. So some matters of direct tax matters may get listed before me, some matters may get listed before the other court. So therefore that kind of distinction, maybe certain norms are fixed, maybe 5 matters in this court, the 6th onwards will be fixed in the other court. So these are the norms which are fixed by the registry and under the supervision, under the guidance of the Chief Justice.
The other issue, sir, comes to everybody's mind is about the fact that today getting justice is expensive. It is inaccessible to the poorest of the poor. It's virtually difficult. I know you have done great work in Nalsa. How are you going to reassure for the poorest man in this country as Chief Justice of India that he will have access to justice and it's not going to be expensive?
See, my work as executive chairperson of Nalsa is a different compartment altogether, correct? As Nalsa chairperson, we have strived hard to say that every deserving candidate, every deserving citizen must get the legal aid. And why do we so? Because if 70% population is below poverty line, then as you said, the process of justice should be very cheap, inexpensive. So for those 70% people at least below poverty line who cannot have that kind of wherewithal or the financial capacity to bear the burden of a long-standing and long drawn-out legal proceeding, so legal aid must be afforded. But theoretically what happens is that the quality legal aid is where we find a lot of questions which are being raised. So therefore more and more pro bono work, if people come forward, render their assistance, then the confidence in the system will get built up, as a result of which the poor people will not feel the brunt when it comes to expenditure on legal proceedings. Then there will be equality. But of course what happens is at times the courts are so overburdened that it becomes physically impossible for the courts to discharge and complete the entire board. In the process, people do get prepared in the matter, they do spend on the fees of the counsel, and therefore the process of court or the pendency in the matter may at times visit people with some financial consequences or overburden. So therefore that is of course, yes, that is true. But then a very holistic and at a very different level the matter has to be assessed. Number one, first of all, whether as a Supreme Court should we be looking into every kind of matter that comes before us. So therefore that's why the debate has to be at a different level.
The issue also comes about under trials. It's sad for them. What will you be doing for that? Because nearly, as you were pointing out, nearly 90% of them are under trials in prison. So
90% of the prison population is under trials. Apply the logic that in only 30% matter the conviction is recorded, which means 70% people finally are acquitted. If you apply that logic 70% to 90%, which means out of 90, 63% will be acquitted. Out of 163, which means more or less whatever is your prison population today, 60% are going to get acquittal. Yet they are inside. Why? There are many questions. One question could be that perhaps there are certain statutes, there are certain legislations which prescribe slightly rigorous standard for release on bail. Say for instance Scheduled Caste, Scheduled Tribes Act, NDPS Act or POXO Act. There are various legislations like this, or say UAPA Act. So therefore people who are...
now even PMLA.
People who are inside, they cannot be released so easily. That puts a burden on the court because the courts are powerless. The courts have to administer the law as it stands, going by the statute, going by the statutory intent. And therefore such applications for bail coming from these kind of variety of strata get dismissed at the trial court level. That adds to the prison population, correct? Therefore the burden. Then in such cases, perhaps one solution could be that very well go ahead and expedite the process of trial. If the trial itself is expedited, then maybe in a year or two, you have the decision in the trial. If the man gets acquitted, naturally he'll be out of the prison, correct? So therefore the process is something as an alternative is to see that the trial itself takes place at an early date, for which again you require a lot of manpower, lot of infrastructure, lot of sort of addition to the number of courts. These are all multifaceted problems. At the same time, for the superior court, the idea is to evolve and declare law as early as possible so that it is followed by the lower courts immediately and at an early date. So therefore that's how perhaps I think to start with, we can start with that. To dispose matters which are actually in the nature of laying down law.
That's a very good suggestion, Justice, but some would say that today a lot of judges are coming under personal attacks, and you've seen that in the recent past. It's become a norm. How do you respond to those kind of attacks that are taking place?
See, I firmly believe that a judge speaks through his judgment and order, and therefore whatever he does, of course in the public realm or in the public domain, that is certainly available to be seen, to be criticized, to be assimilated, to be analyzed by any person, be it a legal scholar or be it any person, be even a commoner. He can certainly stand up and say that according to me the judgment may not be correct for reasons ABC. So long as the objections and criticism is well within bounds, with certain amount of deference, that you are dealing with a judgment, not the judge behind that, correct? Criticize that judgment, criticize the view to the extent possible. You may have a counter view. You may say that perhaps I think the judges failed to understand or take into account the earlier binding view, and therefore say that the judgment cannot be tested on the anvil of the binding law. Certainly yes. So any suggestions, any criticism, any objections, any comments which are within those bounds are certainly welcome, because that's the process of administration of justice, because that furthers the process. The judges also get enlightened in the process. It is true that every human being at some stage may have committed a mistake. So judges also know their mistakes, and perhaps I think they'll be a better lot after these kind of experiences. But at the same time, the criticism should not cross that border or the limit, correct? And to the extent that it becomes a personal attack on the judges, then that's not a good sign for the entire democracy, entire judicial administration. Because today you are attacking one judge. If that culture develops, then tomorrow it will be the in thing that will dissuade good talented people from accepting judgeship. They will not enter the judicial service. That is also something which will be counterproductive to the entire society.
That's an important point, and you are one of those who decided to take up. Sometimes many will ask, why did you decide to become a judge, to give up a lucrative practice? Do you want others like you from the bar to also become judges, or will that be your endeavor?
I will look for the talent. Whoever is a talented person, whether he comes from the bar or comes from the judicial service, is immaterial. The man or the woman must be talented so that he or she can adorn the place here as part of the Supreme Court. And that's where one good judge will always sort of have repercussions, that it will result in good disposal and good quality disposal. And it is good quality disposal which in the ultimate analysis the society will prosper, will gain out of that.
The past records after you all struck down the NJC has been that the collegium is always undecided, can't come to a conclusion on appointing judges. And there's always a deferment or a delay, and that is why we've seen various high courts as well as in the Supreme Court that judges are, there is always a delay in terms of appointment. It's never full to its capacity. What will you do to address this?
See, past experience. Now, the collegium consisting of present Chief Justice Ramana, me and Justice Kanvilkar, that is 1+2 collegium, which was going on from last August, that is after Justice Nariman's retirement. That collegium alone cleared about 255 names, correct? So therefore, there is no question of being indecisive, correct? Not a single.
But you know, before that there was a lull.
Correct. And before that there was a lull for various other reasons. What happens is, if you have collegium which constantly changes, then at times the incumbent takes time to sort of come to the grips of the situation. There was, in the earlier time, there was COVID affected time. So therefore it was difficult for the judges to meet as well. We were doing everything through virtual conferencing. So there were constraints, but nonetheless, to say that the collegium is indecisive may not be correct way of expression. So therefore the fact of the matter is before you. If 255 recommendations could be made within about say 11 months or so, that's a good indication, that's a good example.
So you will work towards fulfilling, those backlog that is there, because many of your predecessors...
Whatever is there, we will try to discharge that duty to the best of our ability. Whether it is filling up the vacancies in the High Court, or whether it is filling up the vacancies at the level of the Supreme Court, we will certainly look into that. But at the same time, what matters most is a talented person, a worthy person, correct? You must get worthy persons.
And that will be decided by y'all?
No, when it comes to High Court, the initiation is through the collegium in the High Court, correct? So therefore they must first of all be satisfied that so and so person, he or she, is worthy of being considered to be judge of the High Court. Then the entire process begins. Then the consultee judges, then the government's inputs, and then the matter comes before the Supreme Court collegium. So therefore the process begins from that level.
There's been also a lot of demand for increasing the retirement age. Do you think that's a fair, good, point that they're
See, now here I'll put only my personal view. We judges work quite a lot. 5 hours which are actually spent in court is just the tip of the iceberg. We have to have backup arrangements. When we come there, we read the papers. After we go home, we have to correct the orders. Those orders again need to be checked every time, because your order has to be perfect every time. You can't just leave the order without any gaps or without any kind of, the infirmities. So therefore that puts additional burden on the judge. Over and above that, he has to prepare the judgments, the matters that he may have actually heard. So all in all, it puts tremendous burden on the judge. I'll just give you an insight. We have a clinic in Supreme Court where it is under the supervision of a lady doctor called Dr. Shyama Gupta. She has been there for more than 20 years. She says that I have seen so many judges who come here, go, after retirement. She says one thing which I have noticed is that if the health condition of a judge to begin with was at X level, he walks out with X plus Y plus Z ailments, correct? So that speaks volumes of what the pressure the judges work under. Almost everybody has some kind of, physical ailment or the other, blood pressure or any such thing. These are all, we call them occupational hazards. Of course, yes. So if you ask me personally, the retirement age should be as it is, because then you have done your best. Now it is for the next generation to take care of the situation.
Okay. The other question, sir, of course, comes on the memorandum of procedure, which is still an unfinished agenda, and there's been a back and forth between the executive and the judiciary. Whenever we ask the executive, they say it's with the judiciary and they have to take a final call. Do you hope, or is there any hope of a MOP ever being finalized?
See, these are questions which perhaps I think will be better answered at the collegium level. So therefore it won't be possible for me to deliberate or even discuss this issue.
But this is in the true sense, the judicial reforms doesn't go forward if you don't address these issues, no, sir?
No, we will certainly address these issues.
I've noticed you have been been a lawyer for top high-profile clients, and then shifted to becoming a judge. But your demeanor has never changed. What's been that secret? Why have you you still remain the same even when you dealt with, say, a 2G case or a high-profile case?
Because that demeanor is nothing but me. So therefore, it's not as if that I am actually projecting something which I am not. So therefore, whatever is part of me will always be part of me.
But when we see you in court, there is so many cases, and as you were saying, so much of pressure, workload and everything else. But you never lose your cool, and you in fact give opportunities to young lawyers.
That is part of legal process itself. See, our legal process is founded on that. Our legal process is founded on one thing, that no man should be condemned without being heard. If you go by that principle, then every suitor, every person who comes in a litigation before the court must have that opportunity. That is part of access to justice, correct? So therefore, any person who comes here, and imagine a man comes here after so much of expenditure, so much of energy which goes into it. He may have had high hopes about a litigation. His perception of a particular litigation may be different than what the judge may carry. But at least he must have a chance to project his viewpoint before the court. So therefore, that is precisely why in my court, I give every opportunity to the person to present his view.
Thank you. This was Justice Lalit, who of course you heard his vision and his plans, and we wish him all the very best as he takes over as the 49th Chief Justice of India.